If you're planning to file for a green card or you already have one pending, a policy change taking effect in about 6 weeks could dramatically expand what USCIS is allowed to hold against you financially, and it directly affects benefits like Medicaid, SNAP, and housing assistance. Welcome back to US Visa News Hub. I'm Mr. Burhan, and if you're not subscribed yet, this is exactly the kind of update you don't want to miss. This video is for informational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney for guidance specific to your situation. On July 16, 2026, the Department of Homeland Security announced a final rule rescinding the 2022 public charge regulation that has governed adjustment of status applications for the past 4 years. The rule was formally published in the Federal Register on July 20, 2026, and it takes effect September 18, 2026. This is a significant shift, so let's walk through exactly what public charge means, what actually changed, and what it means for your specific situation. This video is for informational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney for guidance specific to your case. The public charge ground of inadmissibility is one of the oldest concepts in U.S. immigration law, and it's built directly into the Immigration and Nationality Act. Under INA Section 212A(4), someone applying for a visa, admission to the U.S., or adjustment of status to a green card can be found inadmissible if they're considered likely, at any point in the future, to become primarily dependent on government assistance. This isn't new. What's changed repeatedly over the years is how strictly or broadly the government defines and applies that standard. Back in December 2022, the Biden administration implemented a regulation that significantly narrowed what officers could actually consider when making this determination. Under that 2022 rule, officers were largely limited to counting 2 specific things against an applicant: public cash assistance for income maintenance and long-term institutionalization at government expense. Critically, that rule specified that benefits like Medicaid, the Children's Health Insurance Program, SNAP food assistance, and housing vouchers generally would not count against an applicant's public charge determination. For millions of green card applicants and their families, especially in mixed-status households, that meant using these specific benefits wasn't something that could tank an otherwise strong green card case. That 2022 regulation is what's now being rescinded. In its place, starting September 18, 2026, USCIS officers will no longer be restricted to that narrow list. Instead, they'll have restored broader authority to evaluate all pertinent facts and circumstances on a case-by-case, totality-of-the-circumstances basis, considering the full range of statutory factors Congress originally identified in the INA, including an applicant's age, health, family size, assets, resources, financial status, and education or skills. DHS specifically criticized the 2022 rule in its official rulemaking, stating it was inconsistent with congressional intent, unduly restrictive, and hampered the government's ability to make accurate public charge determinations. USCIS spokesperson Zach Kaler framed the change as aligning immigration law with congressional intent that immigrants in the United States be self-reliant rather than dependent on taxpayer-funded benefits. Here's an important detail about the direction this is heading, based on DHS's own rulemaking language. Legal advocacy organizations tracking this closely expect USCIS to eventually reintroduce a factor weighting system similar to what existed during the first Trump administration, categorizing considerations as positive, negative, heavily weighted negative, and heavily weighted positive factors when evaluating an application. That specific framework hasn't been formally released yet, as of this recording, but DHS has signaled it's coming as part of updated policy guidance, separate from the regulation itself. There's also a related change worth knowing about if you're familiar with public charge bonds, a mechanism where, in certain cases, an applicant can post a bond as an alternative to being found inadmissible. Under the new rule, any public charge bond posted on or after September 18, 2026 will be considered breached if the bonded person receives any means-tested public benefit before they either pass away, permanently leave the country, or become a naturalized citizen, or if they're otherwise non-compliant with the bond's conditions. This is a considerably stricter standard than before. Now here's the timing detail that matters most if you have a case in progress or are planning to file soon. This rule applies specifically to applications for admission made on or after September 18, 2026, and to adjustment of status applications, Form I-485, that are postmarked or submitted electronically on or after that same date. If you receive means-tested public benefits before September 18, 2026, that receipt will still be evaluated under the older, more limited 2022 framework, even if your case is decided after the new rule takes effect. In other words, this isn't retroactively punishing past benefit use, it's about what counts going forward, and specifically about when your I-485 gets filed. USCIS has also confirmed it will be issuing a revised version of Form I-485 to reflect these new requirements, and older versions of the form submitted on or after September 18, 2026 will no longer be accepted. That means if you're preparing to file, you'll need to make sure you're using the correct, updated form once it's released, not an older version you may have already downloaded or started filling out. So, what does this actually mean practically for different groups of people? If you're currently in the process of preparing an adjustment of status application and you're on the fence about timing, this is genuinely a moment where filing before September 18, 2026 versus after could meaningfully affect how your case gets evaluated, particularly if your household has used or currently uses benefits like Medicaid, SNAP, or housing assistance that were protected under the outgoing 2022 rule. That's not a guarantee that filing early avoids all scrutiny, but it does mean your case would be evaluated under the narrower, more predictable standard that's about to expire, rather than the broader discretionary standard coming in September. If you're in a mixed status household, meaning some family members are US citizens and others are not, this is especially worth understanding clearly, because there's been real confusion and anxiety in immigrant communities historically around whether a US citizen child's use of benefits like Medicaid or SNAP could somehow affect a parent's own immigration case. Generally, public charge determinations focus on the benefits received by the actual applicant, not by other household members who are US citizens. But given that USCIS's new detailed guidance hasn't been fully released yet, this is exactly the kind of nuance worth confirming directly with an immigration attorney, rather than assuming based on how things worked under the outgoing rule. If you're an employer sponsoring a foreign national employee for a green card through adjustment of status, this is worth factoring into your filing timeline and case strategy now, particularly for cases you were planning to file in the fall. Employment-based applicants under the new standard should be prepared for more extensive documentation requirements and a more thorough financial review than what's been standard practice over the past 4 years. The bottom line here is this. For the past 4 years, public charge determinations have operated under a relatively narrow, predictable framework that shielded common benefits like Medicaid, SNAP, and housing assistance from counting against green card applicants. That framework disappears on September 18, 2026, replaced by broader officer discretion and a more expansive review of an applicant's overall financial circumstances. If you have a green card application in progress, or you're planning to file in the coming months, this is a genuinely important deadline to understand, and it's worth a direct conversation with a qualified immigration attorney about whether your specific timing and circumstances are affected. We'll continue tracking this story as USCIS releases its detailed policy guidance and the updated Form I-485 ahead of the September deadline. If this was helpful, share it with anyone you know with a pending or upcoming green card case, and subscribe to US Visa News Hub so you don't miss the next update. Thank you for watching. This video is for informational and educational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney for guidance specific to your situation.